I just want to say thanks, John, for doing this. John does a lot of our info sessions. He's a wealth of information, and he can look after your clients with closings, etc. But when I have questions, he's my go-to guy. So let's hear all about environmental this morning, John.
Has anyone ever had an issue with a property with an environmental problem?
I had a buried oil tank once.
Yeah, and that was with a residential property, right?
Yes, it was rural residential, but there was a little pipe sticking up through the paved driveway. So we thought we should ask questions and investigate. And there was a buried abandoned oil tank down there, and it was really quite a bit of a problem.
Oh, so how did you deal with it? So you were taking the listing, right?
No, I was actually working with the buyer, and my buyer walked away from it because it was going to have to be excavated and tested.
All right, very good. So I'm gonna call on you for more information as we talk, because real life information is important.
Okay, go ahead.
So today's topic is environmental. My name is John Poletes. I'm a real estate lawyer. I do real estate closings. I do commercial and residential. We do refinancing. Wills and estates, purchase and sale of business, franchise law, and all the corporate commercial law, including PRECs. I don't know if anyone took advantage of PRECs, but we do them for you. We'll make sure it's done right and economically. This is what qualifies me to talk to you today. So I've been in the real estate business since the early 80s. I know your business, and I've worked in various aspects of real estate. My primary experience is in commercial real estate, but I've also been in the residential business for quite a few years. I've studied real estate at York University. I have a certificate in real estate. I also have a law degree. I also am an instructor for Real Estate Institute of Canada for 3 of their courses. And I also, I have over 30 of my own courses that I teach, 31-hour sessions on all kinds of topics. And the more popular topics are condos, because everyone wants to sell condos. They're easy to sell, but we do need to talk about environmental and pitfalls. So now that I've introduced myself, why is this important to your client? How is your client affected? So Isabel says her client didn't want to deal with it, so he walked away. Was that a good outcome?
Yeah, my client walked away, and I don't know what the sellers did after that, because we asked them to have the tank excavated and the soil tested, and they refused to do it. So I don't know what they did after that.
Yeah, so they wanted you to buy a pig in a poke. Anyone ever heard that expression, pig in a poke? That means buying something sight unseen without knowing what's inside, right? So what's in the ground is always a risk, and it contains liability. Because Isabel noticed the breathing tubes or exhaust gas tubes, or was that a fill tube in the driveway? I don't know what kind of tube it was.
I think it was a fill tube, but it was cut off right at the pavement. Right. So they left the tube open.
Yeah. So because you asked about it, you avoided a situation. Imagine if you didn't ask about it. What would have happened? He may have bought the property.
Well, it was rural residential. It probably would have been buried over and in there for years to come. I'm sure.
Yeah, or maybe he would have found out about it after the closing.
Yes.
And then he would have complained.
Yeah.
And you would have said, I had a warranty in the offer. I had a home inspection condition. And you decided not to go ahead. Is that okay for him? He's still going to have something to complain about, won't he? He'll complain about the listing agent, or he'll complain about the seller.
Well, I think he'll complain about the listing agent, because out on rural properties, especially at that time, it was about 15, maybe even 20 years ago, where it was just coming to light that oil tanks had to be inspected and certified.
Yeah, that was the TSSA rule.
Right. And a lot of, I won't say a lot, some people out in the rural countryside didn't want to do that, so they buried their oil tanks.
Oh, I don't know if they did that, but I do know that
Oh, yeah.
PSSA started making it mandatory inspection. So burying them doesn't help. It makes it harder to inspect.
Right.
So this is why environmental law is important to you as an agent and to a buyer and a seller. So this is an excerpt from the Environmental Protection Act. This is an act that's been around since 1990. And the way it's worded very similar to criminal law wording. It says, Her Majesty in right of Ontario or in right of Canada or any other person has the right to compensation for loss or damage incurred as a direct result of the spill of a pollutant that causes or is likely to cause an adverse effect. What does that mean? How do we interpret this? So who can demand? So this part of the act doesn't tell us who's responsible, does it? It says Her Majesty or in right of Ontario or any other person. So anyone can demand compensation for loss or damage incurred from a spill of a pollutant, whether it causes an adverse effect or likely to cause an adverse effect. So you don't have to prove the adverse effect, you just have to prove that the pollutant was spilled. So this is why it's important. Let's go to the second part of the act here. So section 99.6 tells us who has liability. So it tells us in 99.6 that liability under subsection 2 does not depend upon fault or negligence. Well, doesn't that perk up your ears? So if you're not negligent and you're not at fault, why should you be held responsible? Is that fair? So who is responsible? So it talks here in subsection 7 about who has to pay contribution. In an action under this section, whether the plaintiff is an owner of the pollutant or a person having control of the pollutant, the court shall determine the degree, if any, in which the plaintiff would be liable to make contribution. So who is responsible? Could it be the polluter? Obviously, the plaintiff would be the owner of the pollution, or it could be a person who has control of the pollutant, could be the property owner, or it could be a tenant. It could be someone transporting the pollution. They're responsible under the Environmental Act to make contribution for anyone who can say that they've had losses, to pay compensation. So that's a very broadly worded section. So what does that mean? That means, does that mean that if you buy it and you're an innocent party, so if your client had bought that property, Isabel, would they be responsible for the pollutant of the last guy?
Sorry, if they had bought the property?
If they had bought the property and if there was a stream that ran into a lake beside it,
Yes.
if that pollutant escaped into the lake from the rusty oil tank in the ground, who would be responsible for the pollution if your client had bought it? Would they be responsible?
No, I think the people prior to them would be responsible for not having disclosed it.
So the people prior could have been responsible, but how about your client? What if Her Majesty decided to sue your client for contribution? So the people prior to him had gone away, they'd gone to Alaska, and no one can find them now. And now your client is holding the bag. He's the owner of the property.
Would title insurance cover them?
No.
No. I don't know.
That was a nice try. That was a good try. Title insurance does not cover environmental pollution.
Okay.
So let's read again into the act. Who should be responsible? The person having control of the pollutant. So for the property owner, it could be the property owner, or it could be a tenant having control of the pollutant. So as soon as your client becomes a property owner, he's responsible for the pollution caused by other people. What if the pollution was there from 50 years ago? So Andy here is saying, Christina is saying, wouldn't the buyer have to do the due diligence prior to buying? I think that's a good idea for sure. Leah is saying she agrees. And Andy is saying, I think the buyer has purchased the problem. Yeah, to a degree, the buyer has paid for a problem. How much can this pollution cost? So if the property costs 500,000 and it costs 5 million to clean up the lake, who has to pay? The buyer?
Maybe the buyer's insurance company?
Won't cover it. It happened prior to him buying it. The buyer will be personally responsible, and if the buyer has other assets, he can also lose his other assets if there was a judgment against him. So this is the reason why environmental law is a huge risk for people, because you have unknown risks from prior owners, and it's unlikely that they're going to disclose to you the past risks. And it is very likely that you may be able to sue them and maybe not able to sue them under this Environmental Act. And I'm going to give you some examples of some case law, what the case law says, because environmental law is very case law driven, and the wording of the act is very strictly interpreted. Christine is asking, oh, hang on, there's quite a few things here, quite a few questions popping up. So I think I got everyone's interest now. And I do promise to answer all your questions in the process of the presentation, because because really you're asking me stuff that's in the next slides. Okay. So who is responsible? So the people who are responsible are willing polluters and unwilling polluters, even if it is an accident. So imagine if you have a property on the side of the road. And I don't know if anyone has seen in rural areas, people will put a sign up on their land, and they'll say clean fill wanted. Has anyone ever seen that? Isabel, why do people want clean fill?
Well, if they have a low spot or anything, they want clean fill so that it isn't an environmental concern.
Yeah, they want clean fill to level out their property usually.
Yeah.
Or they may have something that's a little swampy and they want to fill it up, or who knows what the reason is. So imagine you advertise for clean fill and someone comes over and dumps dirty fill. Who's responsible for the dirty fill?
Well, if it's your own property, I guess you would be.
But I wanted clean fill. Am I going to be responsible for someone dumping dirty fill? What if they dump it at night and I never wanted any fill at all and they just come and back up their truck and dump it?
Oh
Who's
my.
responsible?
Oh
Pardon
my.
me? Yeah, so basically this section of the act makes willing and unwilling polluters responsible. So whether you're the victim of pollution, if it's your land, you're responsible, even if it's an accident. If you're the transporter, you're responsible. If you're the property owner of the property where the dirty fill was removed, so imagine that property that had the oil tank in the driveway, imagine if they dug it up and they brought it to Isabel's backyard because she wanted to fill out a wet section there, who would be responsible to clean up that mess? Not only Isabel and the transport company, but also the person who owned the dirty fill in the beginning. So it's a big web. So property owners, from where the pollution was removed, property owners who received the pollution, the polluters are responsible, tenants can be responsible. Any person with control or responsibility over a property can be held responsible or liable, even if the pollution occurred decades earlier.
So can I ask, what is dirty fill versus clean fill?
Sure, of course. Anything that is likely to cause let's look at the definition of what we're talking about. Anything that causes loss or damage as a result of a spill or a pollutant that is likely to cause or does cause an adverse effect. Can you see my slide here where I read you on? Yeah. So the definition is very broad. So there's no list of chemicals. It's anything that's likely to cause an adverse effect. So if they spill peanut butter, even that can be considered a pollution, right? But obviously that's a lot easier to clean up than it is to clean up petroleum, or it is to clean up perchloroethylene. Anyone heard of perchloroethylene? I'll talk about that some more. So basically, someone said we should do due diligence. Early on, when we started, so I think I have everyone's attention now because I can see there's quite a few comments, okay? So this is a law that's not designed to be fair. It's not a fair law, it's an enforcement law. It's not designed to be fair. It can be fair in its practice when a court divides up who's responsible for what. But how do you protect your client? What due diligence do you need to do? Does the seller need to do disclosure? Does the seller have a duty to disclose to the buyer that the property is polluted? How do we determine if the property is clean? And what test should we be doing? Can a home inspector tell us? So in Isabel's case, Isabel had a really sharp eye, but if she had missed it, if the client had an inspection condition, most home inspectors look for buried oil tanks as part of their inspection. They look to see if there's any obvious signs of where you fill them up, or breathing tubes, or air tubes that vent the oil tanks. But generally speaking, we don't rely on inspectors. So Andy's asking about material latent defect. Does anyone have an opinion on that to answer Andy? That's one of the cases we're going to talk about. Okay, latent defects. Paul says, what about soil testing? Leah knows what perchloroethylene is. She knows it comes from dry cleaners. It's a dry cleaning solvent, but there are a lot of pollutants out there. There could be petroleum distillates. There could be perchloroethylene and different ethylene compounds that are from dry cleaning plants. There could be Varsol in the ground. It goes into the water table and pollutes it. So how do we determine what's going on? Everyone's heard of phase 1 and phase 2 environmental reports. What are these? Does anyone know what a phase 1 is? Does a phase 1 give me assurance that there's nothing there?
No, it does not.
So why should I do a phase 1, John? Tell me.
Well, a phase 1, from what I understand, John, is that a phase 1 is a continuation of an initial report where there's an actual site visit by an environmental engineer to determine the possibility of further environmental degradation.
Okay, so basically what John's saying is a phase 1 tells us if we need a phase 2.
Correct.
Is that right?
That's what I believe.
But it doesn't really tell us what the actual condition is of the property. So when they do a phase 1 report, what do they study?
Past history.
So they're looking at past history. They're writing to Ministry of Environment to see if there's a record of environmental spills on the property, or if there's an environmental order. But what other history do they look at? It could be property specific history. So they may look in the land registry office, land titles office, and go back 80 or 100 years to see what the past use of the property is. They may look at aerial photos, historic photos of the property. So if you found a historic photo of the property where it was a historic gas station, would that be a red flag? Absolutely. John's nodding his head. Absolutely, it's a red flag. So basically, these are paper studies. These are studies that are relying on what's documented. but there could also be undocumented pollution. So basically, a phase one is a paper study. In addition to studying the records on the property itself, phase one also studies what? It studies adjoining properties. So they may also do some kind of investigation who the adjoining properties are. So let me give you an example. One of my clients a few years ago was purchasing a property on a retail strip of Yonge Street. And one of the comments in the environmental report was that there was a trace amount of perchloroethylene gas that came up in the sample, in the soil sample. And they actually located where it came from. They said historically there was a dry cleaner to the north of it, and because the groundwater runs from north to south, because of the lay of the land, they believe that was the place that emanated. That was 4 doors over. Is that a problem? So under the Act, who's responsible? Under the Act, who would be responsible? So the property owner would be responsible, and also the property owner of the historic dry cleaning plant that was there to the north. They would be responsible. So we're not going to talk about the likelihood of having it cleaned up, but that's a very common story in a lot of retail strips. In a lot of retail, what I call street malls. A street mall is where you have street shopping, where you can walk in off the street and shop. There was always some kind of a cleaning plant or a paint store that was selling paint, and they would have Varsol, and a lot of these properties ended up being polluted. Also, a lot of gas station sites that were decommissioned in the past may have some trace amounts of pollution if they weren't properly decommissioned. So in this case, what should my client do? Should they ask the seller to clean it up?
Yeah, I think so. The seller has to clean it up if he ever wants to sell it. So why should the buyer have to pay for
it? In this circumstance, the seller was an estate. The estate bought it. They weren't willing to clean it up, and they provided us a phase one and a phase two environmental that they did. And my client said to me, well, I've read the executive summary. They all have a summary in them after they give you a lot of data. And it said that there was a very minor amount of pollution and there was no recommendation. They considered the property relatively clean. Should my client buy it?
Does he love the property? Does he love it?
At the time he loved it, but he wanted me to give him an opinion. Can I give him an opinion on this? So obviously I'm not going to give him an opinion on it.
Right.
It's in black and white, it's in English, and that's not his report. So my suggestion to him was, why don't you hire your own environmental consultant to either look at their data or to get new data and to give us an opinion. So that's called peer review. Peer review is like, a lot of these reports are very complicated and you want to go to another expert because that report was made out to the trust that was selling the property. And as Paul says, get another expert to give us an opinion. So the expert that we got to give us an opinion, I expected him to take a few days or a week to give us an answer. He called us the next day and he says, I wouldn't buy it. I said, well, what kind of opinion is that? His name was Stuart. I said, Stuart, I don't know what kind of an opinion I wouldn't buy it means. He says, look, he says, you have a trace amount of environmental pollution. This type of pollution, perchloroethylene or trichloroethylene, falls into a family of pollutants that are highly carcinogenic. He says the reason they found it as a dissolved gas in the core sample is because they didn't go deep enough to go down to the water table or below the water table to draw a sample as a well. So when they do these tests, they actually drill wells and they sample the water over days. I said, oh, does that mean that there wasn't water there? He says, no, actually, the report said that because the subway is under Yonge Street, maybe we can't reach the water table under the parameters of our test. but I would find the water table if I did the test. I said, why is that? He says, because this is an ESA standard they're using. They only needed to go 20 meters, where if I'm going to be doing this test, I would use an MOE standard, where I would have to drill until I found water, till I got a well. That's a stricter standard. Then I'll tell you exactly what's under there. So basically, he was very risk adverse. So my client reluctantly did not buy the property. Do you think he was angry with me? He wanted the property. He wanted it. He was going to make a big profit on it. Since then, the property has sold twice. Once for the price he paid, and once again about 4 or 5 years later for triple. So if he found out about it, he'd be pretty angry. He lost his opportunity. But what would the risk be? The risk would have been huge to him. Another problem with properties with trace amounts of environmental pollution is who's going to lend on them. So basically, the phase one is a paper report, but it doesn't really tell us. You could have a clean phase one, and if we did a phase two after, the phase two might tell us the property is polluted. I've also seen phase ones where the phase one recommends a phase two. So the example where I had a phase one recommending a phase two was my client was selling a former filling station. For some reason, the buyer waived their condition without reading the phase one. They didn't understand what the phase one said. The phase one says we have no records of pollution, but we recommend a phase two because of the previous use. So on the closing day, the buyers couldn't get their mortgage because the lender read the phase one and said, well, where's the phase two? We need a phase two to close this. So we came to some terms of an extension. So we agreed with them that they would forfeit their deposit, but we would allow them to close with credit for the forfeiture with an extension for another month so they could do their phase two. And they actually came back with a clean phase two and closed it, even though it was a former filling station. And even though the current use was a mechanic shop. And one of the photos I saw of the property is the mechanic had hauled out the engine onto the pavement, and it was dripping all the juices out of the engine onto the ground. And I thought for sure that's going to be contamination. Guess what? In that case, nothing showed up. So basically, without a phase two, you're never going to know what's going on. Someone mentioned the word phase three. I'm not going to talk about it very much, other than to say phase three is remediation. So phase one and phase two are studies and reports. Phase three is cleaning it up. So I kind of alluded to this. How do lenders react? So if you go to Scotiabank or TD Bank and you tell them, by the way, this property has a little bit of pollution, what do you think they're going to do? John's smiling. He's grinning. Are they going to loan you money? Lenders don't like to loan on polluted properties. Let's go to the next slide here. So basically, this is what I recommend for buyers of any property where there's a whiff of any environmental worry. So this is a condition that's in web forms. I like this condition. It's a very nicely worded general condition. It says this offers condition on the buyer determining at the buyer's own expense. All environmental laws have been complied with, no hazardous conditions or substances, blah, blah, blah. It goes on and on, right? Usually, people come to me and they say, I already have a pre-approval for the property and I don't have an environmental condition. Or I do have an environmental condition and I want to waive it because a phase one and a phase two are expensive. Does anyone know how much they cost? And my lender, BMO, Scotiabank, or Royal Bank, or TD Bank, or one of the banks, has come to me with a firm commitment and no conditions in it.
Sure. A phase one, how about phase one between 3,000 and 5,000? A phase two between 15,000, 20,000 and up.
Yeah, did everyone hear that? Yeah, so phase ones are expensive. I've seen them less than 3,000. Depends on the property. It all totally depends on the property. But the idea is, if there's any suspicion of environmental concern that's highlighted by the phase one, that will require a phase two. So when the lender gives us their approval, and we've read the approval, I usually don't see anything about environmental until the funding instructions come to me. That's when I do the mortgage for the lender. So guess what the funding instructions will say? Can you see the slide? Lender requirements? Yeah. So the funding instructions will say the lender requires satisfactory environmental site assessment acceptable to it. Some lenders will only permit certain environmental engineers to do the site assessment. So there's certain lenders that'll say we only use this company, we only use Pinchin, or another lender may say I only use Waterline Environmental. They have their own, the companies that they want. And I told you that a trace amount of dry cleaning fluid is a very common story for retail stores. We had another retail store that my client purchased, and my client needed to purchase it because my client is a dentist, and they needed to buy this retail store because they had rented it. They were at the end of their 5-year lease. They had another 5-year option, and the seller was going to sell the property. We had an option to purchase and the first right of refusal. They wanted to exercise their first right of refusal, or their option to purchase. And my client tells me there's no environmental condition in the mortgage approval. We have a pre-approval from BMO. The closing is coming up in 30 days. Guess what I told them? I told them not to waive their environmental condition and not to waive their financing condition until the closing. How's that possible? Guess what I expected? I expected to see an Easter egg in the lender conditions requiring an environmental report. So my client, out of an abundance of caution, ordered an environmental report anyway. He had it ready for the bank, and it did show a trace amount of dry cleaning solution that emanated from a neighboring property, not even from our property. It's sitting in the ground. What is the impact there? Does it have to be cleaned up? Maybe, maybe not. Now we know about it, but guess who pulled the funding? The bank pulled the funding. So now my client is telling me, how am I going to fund this? I need to buy it. I said, well, you're better off not making a deal if you don't have money. If you don't have money, you're going to forfeit your deposit, right? So what we did is we extended the conditional periods, and he went shopping for other lenders who were more comfortable with the environmental problem. And he did find a lender who was able to do a better evaluation of what the risk was. Sometimes a lender can require you to buy environmental insurance. In this case, it wasn't necessary. The lender evaluated the risk, and we extended the financing condition until the closing day. But it could have been a big problem for them. They needed to buy that place because they were already occupying it. Moving a dental practice full of equipment is very expensive. It's a big move.
John,
Pardon me?
I have a question for you.
Sure.
If a buyer is going to a financial institution and it's obvious that the buyer is interested in buying a commercial building or property, whatever, wouldn't the pre-approval say that the lender requires a satisfactory environmental site? Are you saying that only shows up when the funds are being dispersed, kind of thing? Is that what you're saying?
Not exactly. I'm saying that sometimes it shows up at the end.
Well, that's useless.
Yes, sometimes it shows up at the beginning, sometimes it shows up at the end. Because my client had my coaching, we didn't waive any conditions, and we found it at the end in this case.
Okay.
But quite often people will waive. In the other example I gave about someone buying the gas station, they just goofed up. They didn't understand what they were reading when they read the phase one that they paid for. They didn't understand what they were reading. They were all happy that they were buying real estate, and then they realized that the lender wasn't going to lend. Very simply, they painted themselves into a bind, right? So, Tony's broadloom. Why am I talking about a broadloom case? It's not really a broadloom case. It's someone selling a factory. And someone asked earlier in the chat comments, where does the duty to disclose come in? Someone said, is there a duty to disclose? And someone else said, caveat emptor. So Tony's broadloom is the most, it's kind of the head case in Ontario because it went to Ontario Court of Appeal. So this is the law in Ontario today for the seller's duty. The seller was selling a factory, and I'm assuming that the seller was Tony's broadloom because that's one of the names in the case. They were selling a factory, and in the production of broadloom, they use Varsol, they use solvents. Solvents are used where any type of pigments or dyes are used. So whether it's a printing store or a printing plant or a broadloom plant or anything that uses ink, paint, or dyes, they're very likely to be using broadloom. Where do they dump the Varsol when they're finished using it? Do they dump it down the drain? That would be really bad. Do they save it and recycle it? That would be better, right? And I've also sold places that use Varsol as a solvent without any contamination. In this case, they were pouring it into the ground behind the building. They were pouring 20 liters a day of Varsol for over 6 years into the ground. This is a true story. This is written up in case law. Tony's broadloom, buyer beware. So if you want to read the case, just look up Tony's broadloom and you'll have fun reading. After the closing, the buyer sued the seller. And the court said that the seller has no legal obligation to disclose pollution that does not render the land unusable. That was in the case. So what are they telling us? They're telling us, buyer beware. You can still use the land. You can't eat the soil anyway. Ellen says, should be packed in safe barrels provided by environmental disposal company and shipped off. I agree. This is what most paint companies are obliged to do. Yeah, a lot of paint companies don't even have Varsol. Just go to any paint store and ask for a bottle of Varsol and see if they have it. Or oil paint. They've almost gotten rid of it nowadays. But yes, there are ways of dealing with Varsol. In this case, the buyer is suing the seller because what his argument is that this is a latent defect. You had a duty to disclose this. This is kind of a dangerous condition. And you should have told me. Now I'm having losses. There's a backstory here that I'm saving just for the end. It turns out that this buyer, who did not exercise any due diligence, was buying the property because he wanted to convert it to high density residential. So why do you think he did not tell the seller his intentions to convert it to high density residential?
He was getting a good deal on the property.
Yeah, because it was useless for high density residential because it was heavily polluted. The cost of remediating it would have been exorbitant. He was buying it as factory space. He could have continued the use as factory space to convert it from a factory use or what do they call it, a brownfield use to an environmentally sensitive use where kids are going to be playing in the garden. That's very costly. And that basically rendered it unusable for his intended use. But he didn't disclose that. But this case stands for buyer beware. That's the only thing you have to remember. The law in Ontario is buyer beware. That's the law in Ontario. Anything that's in the ground, you inheriting the responsibility. So it's buyer beware. You cannot sue the seller for contribution. Okay. I gave you a heavy condition to do a phase 1 and a phase 2. On in some circumstances, I give a lighter condition. A lighter condition is client buying a cottage. A few years ago, this is quite a few years ago, one of my clients was buying a cottage and he asks me to help him draft the offer. And I didn't know where the cottage was. It was on a lake. And, you know, other than an inspection condition, I put what I call a flush out warranty. Has anyone ever heard what a flush out warranty is? Am I going to answer that? Flush out warranty is basically a warranty that's to the best of the seller's knowledge and belief. And this is the flush out warranty. This is how it's worded. Seller represents and warrants to the best of the seller's knowledge and belief that during the period of ownership of the property, all environmental laws and regulations have been complied with, and no hazardous conditions or substances exist on the land. No limitations or restrictions affecting the continued use of the property exist. What does that mean? That means we're asking, and he should tell us what he knows, whether he's done it or not. Does that summarize what a flush out warranty is? So my client found this cottage, negotiated for it, and he was in a multiple offer situation. He kept calling me. He says, I'm getting closer, but we're going to move up the closing date. Can you close it? Blah, blah, blah. I said, okay, we'll close it. Don't worry. We had a talk about a survey, and I asked him to order a new survey, which he actually got before the closing. And on the final sign back, because they had priced it at around $369, and they were negotiating at around $300,000. He says, I don't believe there's another offer here, but I'm going to accept the $300,000 now. But look what they did. They crossed out this warranty you gave me. How does this warranty harm them? Why would they cross it out? The seller represents and warrants to the best of the seller's knowledge and belief. Why would they want to cross it out? If they could answer, if they could give us this warranty honestly, so it must mean they know of something. Isabel, what do you think they know about? Your first example.
Either a buried oil tank, or if it's cottage country, it could have something to do with the sewage system.
Yeah, this was an oil tank.
Yeah.
This for sure was an oil tank. And after they crossed it out and we said, we can't go forward unless we know what the pollution is. Guess what they told my client? This was on a Sunday. He's calling me on Sunday. He calls me up. He says, they've crossed it out. I want to accept it. And I said, well, let us bring our own expert there so we can do our own due diligence as to what's happened. What they'd said is that there's an oil tank, above ground oil tank. And for a period of time, there was a small leak from the filter. The filter wasn't attached properly, and it leaked the heating oil into the ground beside the cottage. Is that a problem? Well, the question is, how much was leaked? They told us a small amount was dripping. Drip, drip, drip. Well, my client asked them to give them a one-day condition so they could speak to an environmental expert, and they refused. The next day, the property was sold. The listing agent found out from his managing broker that he should have disclosed that to his own client, that he was double ending it with. They did it an even higher price, $305. He didn't disclose the reason we walked away, but it was never brought to his attention until he found out about the reason we walked away. The other guy bought it. So they decided to disclose to the second buyer. And guess what the second buyer did? The second buyer ordered a phase 2 environmental. And once he found out about the problem, he demanded his money back. The second buyer said, I'm not buying this. I'm not closing with you. My client was really angry that he lost it. and my client was planning to go and buy it from the second buyer. Does that make sense? And then he told me the story of what had happened, that the second buyer didn't own it anymore because he never closed. He found out about the leak. So it turns out from the phase 2 environmental that the second buyer did, that the pollutant had dripped 17 feet below the cottage. That was not a cheap cleanup. And the amount of cleanup depends on the amount of digging and the amount of material they remove. And there aren't a lot of places that are licensed to deal with this material. Usually they put it through a kiln and they burn it off. This required 2 dump truck loads. And I think the closest place was either London or Ottawa where they took them to be burnt off. Does that make sense? So that was a costly remediation. My client ended up buying it, but he bought it cleaned up with a clean environmental report after everything was done. I told you about the story on Yonge Street. Let's skip that. This is a condition that I recommend, even if you don't put anything about environmental. This is what I call an open door lawyer condition. Conditional upon approval of the terms hereof by the buyer solicitor at his sole and absolute and unfettered discretion on both financial and non-financial terms. This is a total way out of any agreement. If you put this in, even if you miss everything in the due diligence, you're gonna save your rear end, your hiney, okay? So let me tell you about as-is disclosures. As-is disclosures, I also call these exculpatory conditions. Has anyone ever heard that? So what is an exculpatory condition? So have you ever seen in a bank's power of sale statement, you're buying it as is, where is, if is? How is that? How does that make sense? Are those binding? I'm going to say to you that if it's not specific about what the as is about, then it may not be fully binding. So for an as is condition to protect the seller, it should be very specific of what condition we're accepting as is. This case is called Antarisa and Imperial Oil. So Antarisa, just to put it into context, is a head franchisor. It's a holding company for a head franchisor that franchises Green and Ross tire and car repair stations. Everyone's been to a Green and Ross at some time. Isabel, ever been there? Yeah, so Green and Ross, they fix cars, fix mufflers, and they also sell tires. Green and Ross, they have a national advertising campaign. They're across Canada. Antarisa was their holding company. And numerous filling stations came up for sale by Imperial Oil. Imperial Oil had merged with another petroleum company. And because of competition law, they were forced to divest themselves of numerous properties. They wanted to buy, I think, 4 gas stations and convert them to Green and Ross franchises. They had the people in place. They were going to start making money right away. So after the closing, they sued them for the environmental pollution that they found was in the ground. So what is their argument? Their argument is latent defect. Yet the court looked at this and they said, you know what? You have an exculpatory provision in the agreement and also in the offering memoranda. It says here that the buyer has been made aware that this is a historic filling station. It was used for the storage of petroleum distillates, and it is very likely that there's spilled petroleum distillates in the ground. The buyer is relying on its own due diligence and accepts the property in as-is condition in this effect. Guess who they called in as a witness? They called the buyer's lawyer as a witness. And the buyer's lawyer actually provided notes that they warned their client that they should do a phase 2 environmental. Can you believe that? So guess what the court said? This upholds Tony's broadloom. Buyer beware. There's no possibility to get recovery if you're accepting something in the ground. So when should you have an environmental condition? You could have it in an offer to lease, whether you're the landlord, you don't want your tenants to be polluting because you're going to be stuck with it. You could have it for residential property. So it's not just commercial property. It's not just limited to fuel tanks and buried fuel tanks. You could also have septic systems that need cleaning up and decommissioning. You could have adjoining properties that are in the neighborhood that are not even adjoining your property. Maybe it's close to your property. You could have a fuel station that's contaminating the groundwater. You could also have radiation in the ground. So anyone heard of Port Hope or Coburg? Coburg and Port Hope have radiation. It's written on every deed of a Port Hope property. There was a historic munitions plant, and they were dumping irradiated material on the ground, and now it's carried around in the dust. So if you're there, you're breathing it. A lot of people like to go there to retire. I don't know if I'd want to go there to retire, Port Hope. I've even seen an article about where the government plans to move the whole community, but it's billions and billions of dollars to move a community like that. So remember these things. These are takeaway points for you. You need a seller's warranty and representation, even if it's a flush out warranty. You may need a due diligence condition for a phase 1 and a phase 2. And if your client doesn't want anything, use Form 127. Show that your client had the opportunity to have an environmental inspection and they didn't want it. I would put that in my Form 127. And if they don't want any of this, you can put a lawyer's condition. And I gave you a nice lawyer's condition. This is what the code, these are very general provisions from the Code of Ethics. If you make a mistake and someone says you didn't take care of your client's interest, this is the section they're going to be reciting. You have to promote the best interests of your clients and provide careful and conscientious service, demonstrating reasonable skill, knowledge, and judgment. These are my coordinates. Any questions?
Hi, John. Good morning.
Hi.
I have a question for you. This is Leah Mills. We've been talking a lot about what happens on the buyer side. What if you're listing something like, let's say, a residential property and it's a farm, so a lot of machinery in that. If you're on the listing side as an agent, what tips or points would you maybe provide to us to be cautious for, what to look for in that regard?
Yeah, I would ask the seller. I would ask the seller if they have any known environmental risks or pollutants. To be quite honest with you, it puts you into a hard spot because the Code of Ethics, Section 21 of the Code of Ethics, has an onerous provision in it that says you have to not only disclose, but you have to take steps to determine any facts, material facts that may influence someone's decision to buy or not to buy, sell or not to sell. So in a sense, this provision of the Code of Ethics puts you into a bind because if there is a problem, the seller can't tell you, don't tell them, because the seller has no obligation to disclose, but you do. So you're kind of you have a contrary interest to your seller. You would have to resign if your seller wasn't willing to disclose a problem, because your duties under the Code of Ethics is to disclose the problem.
That's right. And I think my further sort of sub question from that is our education of knowing what could be a problem as well, right?
The problems with environmental are very general. There could also be problems with the house itself. So if you're selling, we have seen people that are selling commercial properties do their own environmental testing. They'll do a phase 1 and a phase 2 to make it easier for someone to buy. I recently sold a printing plant as a lawyer for my client. My client was the printer. He ran the plant for his whole life, for like 25 years. He ran it. He had no succession plan. And most of the printing has gone to China now. It's gone overseas, offshore. So he just decided not to be printing anymore. So it was in an area of Etobicoke that's becoming residential. and the buyer wanted a clean environmental. And their environmental report came late. When it finally came in, we were able to find out that it came out clean. And he was using a lot of Varsol. So how did it come out clean? Because he was disposing of the Varsol according to ministry approved standards. So he was collecting the Varsol in special containers. So in his business, he wasn't using liquid Varsol that he would dispose of. He would soak it onto rags and clean the printing presses. And after he was finished cleaning the printing presses, he would dispose of the Varsol in special containers, and a service would come and pick them up and dispose of them for him. And he followed these procedures very carefully, so his property was clean. So he had a very nice retirement plan without a problem. He had a nice paid off property there.
Good stuff. Thank you, John.
So Isabel, thank you very much for the opportunity to speak to your gang today. I hope everyone got a benefit out of it. And remember, my advice to you was put a condition in the offer or put a warranty in the offer. And if you can't do that, put a lawyer's condition and let their lawyer be responsible. Let him figure it out. Does that make sense? Don't let it go on your insurance. Don't let there be a RICO complaint. You should always have your ears open to these problems. Not everyone has an eagle eye like Isabel who can spot the vents coming out of the ground. I wouldn't have noticed it, vents coming into the ground. My client with the cottage property, he noticed the oil tank, but he didn't notice it was leaking. But I'm sure if he looked at it very carefully, he would have seen one little droplet of oil on the edge of the filter or a dirty cinder block that it was sitting on, right? But that's not everyone notices. That's why we need to rely on experts, or in absence of that, have a condition.
Thank you so much, John.
Thumbs up. Thank you, Isabel. Take care.